Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law Section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law, and casual listeners interested in hearing a lively discussion on these topics. Each episode is presented by one of the specialty committees within the section. I'm your host, Anant Raut. This episode is part of an ongoing series we're producing and co-hosting with the Trial Practice Committee of the Antitrust Law Section, in which we present oral histories of some of the most important cases of our time, as told by the lawyers who litigated them and the judges who presided over them. This episode is on in re Capacitors antitrust litigation, better known as the Capacitors trial. Capacitors are electrical devices used to store electrical charge. If you've ever looked at a circuit board, you would recognize them as these tiny rubber-coated barrels with two wires coming out of them. Capacitors can be composed of a variety of metals and are a necessary component of electrical circuits. Put it this way, just about every electronic and electrical device you're familiar with has capacitors in it. Trillions, with a TR, of these little things are produced every year. The worldwide market for capacitors was over $30 billion last year. An investigation by the Department of Justice starting in 2014 uncovered a conspiracy among a number of manufacturers, many of which were based in Japan, to collude to raise the prices of certain electrolytic capacitors at various points over many years. The DOJ ended up charging 8 companies and 10 individuals. All 8 companies pled guilty and agreed to pay fines totaling $150 million. Private litigation followed quickly thereafter. A class of direct purchasers brought a lawsuit alleging an illegal price-fixing cartel against 23 manufacturers of aluminum, film, and tantalum capacitors. By the time the case went to trial, all but 3 defendants had settled. The trial began on March 2, 2020. 9 days later, on March 11th, the World Health Organization declared COVID-19 a pandemic. Federal government functions began shutting down, along with many other parts of society. In the face of a global health crisis unprecedented in nearly a century, the court had no choice but to suspend the trial on May 16th, eventually declaring a mistrial on June 4th before a verdict was reached. Over a year later, in November 2021, the case went to trial a second time against the 3 defendants, Nippon Chemical, United Chemical, and Matsuo Electric, before a new jury. What happened in that second trial, and putting on a case not once but twice in the midst of a worldwide pandemic, is the subject of today's episode. Joining me today as my co-host is Chris Young, a partner at the Joseph Saveri law firm. Welcome back, Chris.
Thanks, Anant. Good to be back.
Chris, why are we talking about the capacitors case today? What is significant about it?
Well, Anant, there's a couple of reasons why the Capacitors trial was fairly significant. Well, first, it was one of the first major class trials to go to trial after the pandemic was declared, and certainly one of the first trials in the pandemic era to involve a cartel with multinational defendants. Second, the Capacitors trial is significant because it was such a sprawling case. Before we entered into the trial, there were a significant number of settlements that were reached. One of the strategic implications for both sides was how to approach damages and the implications for the result of the trial there. And lastly, it was a case that involved numerous guilty pleas and a para-applicant, but not all of the alleged conspirators had pled guilty. So one of the strategic implications was how the parties would deal with that. On plaintiff's side, how to get at the other parties who did not plead guilty, and for the defendants, how to either defend their client who may have pled guilty or to distance themselves from those who did.
We're lucky to be joined by some of the attorneys who litigated this case and the judge who presided over it. I'll start by letting the attorneys go around first and briefly introduce yourselves.
Thanks, Anant. As you mentioned before, I'm Chris Young. I'm a partner at the Joseph Saveri law firm. We represented the direct purchaser plaintiff class that brought the civil case.
I'm Steve Williams. I'm at the Stephen Williams Law PC firm. I was at a time lead counsel for the indirect class in this case, and then I joined the Joseph Saveri law firm where I was co-counsel and tried this case.
I'm David Cross. I'm a partner at Morrison, Foerster, and chair of MoFo's antitrust litigation practice. We represented Matsuo as one of the defendants in the price-fixing trial that we're here to talk about.
I'm Meg Webb. I'm an associate at Morrison Foerster, and I was also part of the team representing Matsuo.
And we're also pleased to have the Honorable James Donato, District Judge for the United States District Court of the Northern District of California, who presided over the trial. Welcome, Judge Donato.
Happy to be here, Anant.
Chris, I thought we'd start by talking about the defense's approach to damages. So the defense came into this case with the plaintiffs having already secured a considerable amount in settlements, right?
Yeah, that's right. So coming into trial, our expert had calculated roughly $427 million in single damages. And the total settlements as we started trial numbered roughly around $435 million, which exceeded the single damages number our expert calculated. So that was a particular strategic consideration, given that if the verdict came in under that number after trebling, there would be, with offsets, that would effectively mean no liability or no recovery for that defendant. So one of the things that we were considering on plaintiff's side is how to navigate that consideration. And David and Meg, I'm actually curious about how this affected your strategy about how to present the case with that kind of landscape and the settlement landscape around your client.
Well, first, Chris, I have to tip my hat to you and Steve that you were able to generate settlements that exceeded the money you were owed on single damages. That's no small feat. So very impressive. And of course, it did have upside for us at trial because from our perspective, any damages number in the range of 140 to 150 million at offset was going to be zero or something very small across the defendants at trial. And so unlike most trials where we'd be coming in really focused on trying to get the damages number to zero or to a really small number, that gave us a lot more latitude in terms of planning for trial and how we would approach the damages number, particularly in a case where we have guilty pleas, right? My client pled guilty. To be clear, they did not plead guilty from our perspective to the conspiracy that was alleged in the class case. Chris and Steve, you may have a different view on that, but that was certainly our view. And so we were focused on trying to get to a damages number that at the end of the day meant our client paid very little or hopefully zero. So it changed the perspective quite a bit. And Meg, you should jump in because you and I work closely together in terms of how we were going to put on the experts and put on our strategy.
No, I think that's exactly right. And we were considering was focusing on trying to show the jury that the extent to which our client had pled guilty was a much narrower conspiracy than what was alleged in the class case. And so focusing on limiting damages rather than denying liability entirely.
If I could just comment for a moment, and thank you very much, David and Meg. I think this is a key point you're making that is important to consider the case is what we were trying to prove was very different from what the DOJ had alleged and what the guilty pleas said. And it was a much larger conspiracy. So there was a lot of merit to the argument of saying this is not what we pled guilty to. It's not what we're liable for. And it also, significantly overlaid the damage analysis on both sides.
One of the things that occurred to us, at least when we were trying this case, was the importance of experts. I mean, it's no secret that in civil cases, damages numbers are coming through expert economists or econometricians or statisticians. And Judge Donato, I know that you had some thoughts about how to most effectively present the expert testimony. So I was wondering if you could share some of those thoughts with us.
Yeah, happy to do that. So let me age myself greatly by telling you, when I started practicing in the 1990s, the way we approached experts as a profession was very different from what happens now. So back in the 90s and even up through the first decade of this century, the 2000s, experts were still presented as vigorously as we could at trial as independent. And so there was always a preparatory exam when you put your expert up for the first time to try to persuade the jury that this person was taking a fresh, clean, unbiased look at the data. Both sides would do this, and there was always an uncomfortable moment when it was revealed how much each side paid the expert. Today, I can say that after 10 years of watching expert presentations, that I think the profession has changed on that. There's no longer any effort to try to portray experts as being independent, who just happen to be working for one side but are giving an independent view. It's very plain now to the jury and everybody in the courtroom Experts are being presented as essentially paid spokespeople for the party who is sponsoring their testimony. The result of that is, I think lawyers tend to overvalue the role that experts have with jurors. Now, I often talk to my juries after cases. I did so in the Capacitors case as well. And I think it would be surprising to many lawyers to hear, after all the time and money they spend, the jurors take a fairly jaundiced view of what experts are saying. Now, an expert properly done is going to be someone that helps the jury understand things that they can't get on their own. That's what an expert is supposed to do. That's the purpose of an expert, to help the jury understand things they can't figure out without some guidance or teaching. But they're very wary of taking the expert opinions without a pretty significant grain of salt, knowing that they are there to peddle the perspective of the party that has sponsored their testimony. So they're important. Yes, you have to have them. In Section 2 cases, absolutely. In Section 1 cases, generally, yes. Are they going to kill your opponent with their devastating testimony? Almost certainly not, unless something has gone wildly wrong. And I think for the most part, jurors will take an expert, but they're not going to be banking their verdict entirely on what that expert has to say.
And Judge Donato, I found that interesting when we were talking about it earlier, that lawyers need to think of these jury trials as a show and how to judiciously use the presentation to keep the jurors engaged with what you're trying to get them to come away with.
Well, yeah, okay, that is a good point. Now, this often gets lost, particularly as judges and lawyers, do fewer and fewer trials. It's a show not in the sense of a night's entertainment, obviously, but it's a show in the sense of telling a narrative story that makes sense to people without having to have to do a lot of song and dance about, no pun intended, a lot of song and dance about the law and the technicalities of whatever an expert may be saying in his or her testimony. So, jurors come in, we're programmed as people, evolutionarily, societally, to hear a story. And we react to stories. And in price-fixing cases, there's a very good story. There's a very good story on both sides. Plaintiffs have a great story about backroom conspiracies and people scheming to cheat the public and steal their money. And defendants have a very good story about, this is how industries work. And it may be that we all come together on more or less the same price. That's not because we're conspiring. It's because that's the economy working the way it should be. We're all competing at the margins. We're fighting hard with each other, and this is good for everybody. And so what gets lost, I think, particularly in some of the longer antitrust trials, when you have more time to burn as lawyers, you're not under a clock, which I think is quite helpful for the litigators. You start to get into crannies, nooks, back alleys that lose the narrative thread for the jury, and the jury kind of checks out. The one thing I will say in terms of practice also is that a lot of lawyers stop looking at the jury and how the jury is responding during a lot of this testimony. And so they don't see that pencils are down, pens are down, the jury's not taking notes, they're looking around, they're checking their watches, they're looking at each other, they're looking at me, they're doing everything you could possibly do to signal that you have lost their attention. And the lawyers often just don't pick up on that because they get kind of enthralled with their exams. They put a huge amount of a huge amount of resources into them. They've rehearsed them. This is their moment. And they forget that it doesn't matter at all if you've lost your audience. And I think that's a big problem when we get into trials of this sort. So if there's one takeaway I think people should take with respect to the show point, Chris, is you do have to keep your audience engaged. And remember, it's a dialogue. You got to look at them, watch them, see what they're doing. And if they're not responding, if it's a dead room, it doesn't matter what your witnesses are saying because nobody's hearing it.
And I would love to underscore that because to us, we're on the plaintiff side, so we're sitting closest to the jury, and we would have people in our table who were just paying attention to the jury the whole time to make sure, are they paying attention? Are we losing them? So we would move along. Because one of the things to me about the show too is, and this is something I learned in one of my earliest trials, is you can't have gaps or pauses in your presentation. You have to stay engaged with the jury at all times to keep their attention. and you've got to be really focused on, are they listening to you and are they paying attention to you? And it's absolutely right. Some of the lawyers forget to pay attention to the most important people in the room, which is the jury during trial.
And one thing I would just echo is the judge's remark about the importance of a clock. It is surprising to me that more judges don't do clocks. I've actually asked for it in trials, including a recent trial where the judge declined it because the other side objected. And, I think we saw this play out in this particular trial. And Steve and Chris can speak to it from their perspective, obviously. But, when the trial began in 2020, we had considerably more time than we ended up for the retrial. And, I think both sides were looking at how we were going to squeeze that in. I know that, Steve and Chris were working to wrap up their case before we went into the mistrial. But coming back the second time with a lot less time just had us much more disciplined, I think, on both sides. And I really wish judges would do this more because, in my experience, lawyers are infamously bad at imposing their own discipline. They're going to fill the time in exactly the ways that the judge has described that's often unhelpful. And so putting everybody in a clock it brings a level of discipline that I think not only helps the jury and the judge move through it efficiently, but forces the parties and their lawyers to focus on what really matters, which is better for everyone. It's better advocacy and presents a tighter, more effective case on both sides.
Yeah, Dave, that's a very good point, because one of the challenges we did have was, we had a very limited amount of time to tick all the boxes as to every defendant, make sure we hit all the elements of all of the claim as to all the defendants. So there were a lot of hours planning, looking at all the testimony that was coming in and really mapping out, not just, with the defendants who were in the room, but for all the absent defendants or all the settled parties who weren't in the room, just to make sure we covered all our bases there. So, just being very disciplined about that analytic, really analyzing the kind of legal elements was very important, at least from our perspective, and was a lot of our time, at least.
Chris, let's move on now to the next section, which is about drawing inferences from guilty pleas. You had an interesting situation here as the plaintiffs in which some of the parties in this conspiracy had pled guilty, but not the defendants in this case. What kind of challenges did that present to you?
Yeah, so coming into this case, there was an at-para applicant. There were, I believe, 6 corporate defendants who had pled guilty, including David and Meg's client, as well as some individuals who had pled guilty as well. But importantly, I think it was one of the themes was that there are a very limited amount of parties who actually pled guilty. A number of the corporate family members of the defendants did not plead guilty, and a number of defendants who were outside of those corporate defendants we alleged to have participated in the conspiracy, but did not plead guilt. So one of our challenges was how we really tied that in, how we really, I don't want to say, associate the people who did not plead guilty with the guilty pleaders, but to really show that, these people were all in the same room and participated in the same meetings. Steve, and maybe you can help, provide some of the color as to some of the things we were considering. But I do know that this was one of the biggest considerations we were thinking as we were thinking about how to present our case.
Yeah, it was challenging in that this comes up a lot in antitrust cases where there are parallel criminal proceedings, but you don't often actually get to the point where you're asking a district court to give you inferences. And I would say that we had to redo our approach to it because we started with a much broader approach in terms of the inferences we were seeking to have drawn from pleas. And I think the reality was you need to be very focused both in when you're taking the deposition that's going to invoke Fifth Amendment invocations and get very focused questions that can be used later, and then be very focused and narrow in terms of the inference you ask for from the court. Because the inference is so powerful and strong, I think if it's granted that it's got to be very well supported and narrowed. And I think that was one of the key experiences. As Chris had said, and as we commented earlier, there were defendants in this case who were not alleged by DOJ to be part of any conspiracy, and we wanted to use some of these invocations to tie them to the conspiracy because they had invoked the Fifth Amendment. And the learning curve was that be narrow and be focused and don't overreach in terms of those submissions and make them easy for the court too. I think one of the things we learned, we had been providing the court with things that were the size of a small dictionary to support our motions. And that wasn't really necessary. It was really much more, give me the precise inference, give me the precise evidence, give me what supports it. So it was narrowing and focus. And I think one additional thing that also tossed a wrench into this was some of these Fifth Amendment invocations were withdrawn just before the first trial, and those witnesses then testified. So that also changed the playing field for us a little bit.
So one of the things that I was interested in hearing is that Meg and David, you represented a client who had pled guilty, and also one of your key witnesses was an individual who had pled guilty too. So I was just wondering how that colored how you wanted to present your case or your strategy approaching trial.
Yeah, I think our strategy was really twofold. Number one, with respect to our client and the witnesses that had pled guilty, we wanted to show that the scope of the conspiracy alleged by the class was much broader than what they had pled to. Our client pled to a very narrow, limited conspiracy involving a limited type of capacitor and a limited scope of other companies and specific events. And the conspiracy was a sprawling 12-year-long conspiracy involving lots of other defendants. And so we wanted to show that to the extent that we did plead guilty, it was a much narrower conspiracy than what was alleged in this case. And then number two, more broadly, just to show that the conspiracy included lots of defendants and products that were never at issue in the guilty pleas or the DOJ investigation. For example, there was American companies that were included in the class case that didn't, from our perspective, have anything to do with any of the guilty pleas or the alleged conduct involved in the DOJ investigation. So that was sort of our goal, was to show that the conspiracy was, as alleged, was much broader than any of the evidence actually showed.
Yeah, and I would just add, that Mr. Okubo, who testified for us, was always going to be one of our key witnesses. He pled guilty. And, part of what we wanted to get across to the jury with him was, he's someone who did a bad thing, but that doesn't necessarily make him a bad person. And, we spent a lot of time with him, Meg more than others. He's a genuinely good guy who made some bad decisions and took accountability for it, unlike a lot of other folks. There are a lot of folks that avoided culpability in coming to the U.S. to plead and to take responsibility, which he did. And so that was a key theme for us, was to get across to the jury that we weren't running from anything. Our client wasn't running from anything. Mr. Okubo wasn't running from anything. They had come to that courtroom. They had taken responsibility. And he was there to testify live. And we wanted to really humanize him with the jury so that they understood that, someone who made some bad decisions, but it doesn't mean you should come in and give the class everything they're looking for, because in our view, the narrative the class was presenting, as Meg described, was much broader, much more encompassing than what Mr. Okubo and others at Matsuo had done. And that's what we hoped to get through from him, is what we thought and hoped would be a credible witness, taking accountability for what he had actually done.
And I want to note that Mr. Okubo's presentation and how he came across, in my view, and I deposed him and examined him at trial, was very different than, for example, a witness for one of the other remaining defendants who also had pled guilty and then revoked his invocation, but in my view was much more combative about what had happened than Mr. Okubo, who did seem like he was really trying to be much more straightforward.
Judge Donato, how did you end up deciding this issue?
Deciding the inference issue?
Yes.
It's actually less complicated than it might seem for two reasons. The best way to manage the inference, in order to give the plaintiff the right they have, which they are entitled to an adverse inference in certain circumstances, and balance that out to be fair to the defendant and make sure that it's not going to unduly influence a juror, is just manage it through the jury instructions. So I spent an enormous amount of time crafting those instructions to make sure that the jury got a very balanced message and was quite clear on what they could and could not do with respect to an adverse inference. So that is the main way to kind of handle it. I will say also, we work very hard in voir dire and in the screening we do to make sure that we get jurors that have a fundamental sense of fairness. And I think we're extremely successful in that. Most jurors get it. You can have a group of 12 people, maybe 7 of them did something that was not right, but people's individual sense of fairness is very open-minded about the other 5. I mean, I know that the people who are the target of adverse inferences don't feel that way. I get that. I don't think that's borne out in the way juries actually work. I think juries are very fair. They have an innate sense of some people are different from others. Some people make poor choices, some people don't. And they're not going to paint with, a roller. They're going to paint with a fine, brushstroke to make sure that they capture the right people. So I know adverse inferences are terribly stressful for the parties, but I have a lot of confidence based on evidence I've seen with the way jurors handle it. And I am not at all concerned that they become a tool of misuse in the jury's hands. Quite the opposite.
Now, one thing I would just follow up on, I think it was Steve who mentioned that in this case we had invocations early on that then were withdrawn shortly before trial, particularly before the the original trial in March of 2020. And from the plaintiff's perspective, I totally appreciate that's a frustrating dynamic, right? You went through discovery, you tried to depose these people, they took the fifth, and now you're preparing for a trial, and these folks now want to testify substantively. Completely get the other side's perspective. What I would add to that is, when you have the criminal investigation as an overlay or as part of what's happening with the civil piece, that adds a level of complexity for everyone, right? Because, from our perspective on the defense side, we have clients who don't really want to invoke the fifth, right? They want to be able to come in like Mr. Okubo and say, look, this is what I actually did and this is what I didn't do. They want to come in, tell the truth, and cabin what they actually did and what they should be held accountable for. But when you're in the throes of a criminal investigation and you're not sure where that's going and what's going to come out of it and the exposure that has, almost always your client is going to have to take the fifth, at least until the criminal piece has played its course and you have a fuller understanding of what the exposure is there for folks. And so it necessarily is going to happen in many of these cases that your client is going to take the fifth early, and then later when the criminal exposure is gone and they're just facing the civil, now they can kind of tell their story in all its detail. That happens. And I thought, here Judge Donato handled it, in my view, exactly the right way, which was to say, go take these depositions. Everybody, I think, coordinated and cooperated to get it done quickly as we went to trial. But it's a difficult situation that's frustrating for both sides, but I think we got to the right result here in terms of the way it played out. In fairness.
Yeah, I agree it was the right result. And though we might have been frustrated at the beginning, I think our view, and I got to give a great deal of thanks to Chris for this, because these depositions literally, if I recall, happened just before the trial was going to happen. And they were extraordinarily beneficial because these were high-level people, and it was the first time they actually testified to what had happened. And I thought that testimony was critical to the plaintiff's presentation at trial.
Yeah, I think that was right. I remember it was Steve and I think sitting for 8 straight days doing 4 witnesses of depositions, and the last day coincided with one of the final pretrial conferences. So I remember, I think Meg was there too. So in lieu of going to a pretrial conference, I think there were 4 attorneys just deposing one of these witnesses.
And note as well, Chris, in foreign language as well.
That's right. Yeah, but I do think that testimony was key, and ultimately I think there is always a preference for substantive testimony rather than having a jury rely on the inferences. And I think what came out those days of deposition really did help at least tell a more fulsome narrative story for the jury.
And on that point, Chris, whether there's always a preference, from the defense perspective, sometimes it's a close call, right? I mean, to what the judge has to say, I completely agree that I think jurors tend to be fair in the way that they construe inferences. They try to be narrow about it. And so part of the challenge on our side, right, is what's better for the client? Is it sitting them in a room now where they're going to answer your questions and you guys get to take them in all the different directions and dig into all the facts you want to do, or stand with the invocation and then you're going to argue the inferences? What's better for the client at the end of the day is not always an easy decision, because you may learn a lot of things in a deposition that you otherwise wouldn't have for trial. But on the flip side, you've got inferences that are going to the jury that are bad. And so there's a judgment call to be made there. And obviously our judgment here was we felt comfortable putting our folks in a room with you guys to learn what you were going to learn and to have them tell their story.
Chris, let's move on now to what I found is one of the most fascinating aspects of this case, which is the extraordinarily unlucky timing during which it took place. A worldwide pandemic, the likes of which hadn't been seen since the Spanish influenza. What were the challenges of going to trial during a pandemic?
Yeah, so there were a number of challenges. I mean, first and foremost, I mean, the lead up to the first trial in early 2020, the signs were already kind of there. I remember one of the things that really struck me as we were preparing for trial was, we were coming into court every day, and at least I would notice that like the streets of San Francisco were getting thinner and thinner and less crowded. That being said, we still had a case to present. And, by the time mistrial was ultimately declared or the trial was paused on March 20th, 2020, we had already nearly finished our case in chief. And when we were gearing up for trial 2 in November of 2021, one of the things that I'm sure both sides were thinking about was how to approach that, given that we had essentially played many of our cards. So, Steve, I was wondering if you could, tell us a little bit about how we thought through that and how we decided, or some of the strategic considerations about how we presented trial 1 and what we were thinking about doing for trial 2.
Well, the thing to me that was strange about trial 2, I shouldn't say it that way. There were a lot of strange things about trial 2 was for a lot of the evidence and testimony that was put in, it was the exact testimony from the prior trial because the pandemic or aspects of it were still going on and witnesses weren't coming back. So we were confined in many cases to the testimony they'd given before, and it was all presented through readings and actors who came in to read testimony. And it was a really strange feeling because in the first trial, when you're doing live examinations and you have that adrenaline and you have, your intensity, you're all focused. But when everyone knows what's coming in because it's just a repetition of the testimony before, it was almost more of an effort to keep focused with the jury because they didn't know this had all happened before, right? We know we're rereading stuff that we all saw before. But that was a big challenge. And a second challenge was the fact that there were witnesses who had not testified in the first trial that we had on our list that we had significant doubts if we could get them to come because witnesses in foreign countries, particularly in Asia, had no desire to come back to the U.S. or to come to the U.S. at that time for a trial. And it was a bit of a game of chicken with the defense in terms of which witnesses we thought we could bring and which witnesses we were not going to be able to bring. And I think the last part would be, reevaluating and regauging what worked the first time and what didn't, recalibrating some expert issues from the first case because the presentation got narrower in the second case. And there were some issues that came up with an expert that required a lot of debate and discussion about what role, if any, that expert would have in the second trial, which was key, again, because we were litigating to get to that number where there would be no risk of set-off to the plaintiff case. So a lot of those things were floating around as we came into that second trial.
Yeah, just to add on to that, and one of the considerations we had for the second trial, Steve, was that a number of the settlement agreements we had reached with the parties who were not at the trial was non-monetary consideration in the form of cooperating witnesses. And given that a lot of the witnesses were in Japan, and Japan had very strict COVID restrictions. For example, there was quarantine requirements for witnesses traveling out into Japan. We had considered seeing if we could get remote testimony from Japan, but Japan actually has a law which prevents anyone located in Japan from providing remote testimony from Japanese soil, which made that kind of a non-starter. So there were a lot of difficulties in obtaining the cooperation, which I think was a key part of at least how we were considering presenting trial 1 versus trial 2.
And Chris, is my recollection correct that you also and some other attorneys had to go to Hawaii for additional deposition just before
I
the second
did not,
trial?
but I believe a witness did have to go to Hawaii, and I believe Meg can tell us more about that.
Yeah, we were planning to offer a witness at trial who had not been deposed previously, and so the parties agreed that he could be deposed before trial, but there was quarantine restrictions that made it impossible for him to come to the US, and then Hawaii lifted its quarantine restrictions, and so we ended up having him fly to Hawaii, and the deposition was still remote, but his testimony was given from Hawaii because, as Chris said, there's restrictions in Japan preventing remote testimony in Japan. So we had quite an international deposition happen there.
Before we leave the COVID point, let me add, we're getting a little time and distance now. We get a little bit more perspective on it, and it seems, as we get farther away, just how unusually unique and maybe even bizarre that situation was. I have to say, I think the litigants and the jurors and the court system on our end really, I think, rose to the occasion in a very strikingly impressive way. Now, my main concern as a judge was, in addition to everything else you have to do in a major trial like this, is making sure everybody stayed safe, which was an enormous amount of work. It started with, we instituted as a district for the first time a mandatory written jury questionnaire, much of which was directed to pre-screening for COVID vaccinations, health checks. We had to seat jurors separately, which with a little space in between them, which when you have a jury box of 14, you have, an 8, 9, or 10 jurors is actually kind of hard to do. It's a real burden to be in a courtroom for 6 or 7 or 8 hours and then in a jury room with a mask on that entire time. The jury rooms themselves, as if you've ever been inside of one, is a standard feature of federal courts throughout the country, not designed to make you linger in comfort. They're designed to get you to a verdict. So they're small, tight, windowless spaces for the most part. And it's when you're there sitting, am I going to walk out of here with what at the time we thought was a potentially deadly plague, added a lot of stress to jurors that I had to help manage. We all got through that, I think, and the lawyers and everyone involved, the jurors themselves get tremendous amount of praise. My court staff was heroic in handling it. The worst nightmare a judge has in that situation is that these people who drop everything at a moment's notice to come in and be jurors for 3 weeks come down with a potentially life-threatening illness. And we avoided that. We were very lucky to avoid that. The one interesting downside, though, as some of the lawyers have alluded to, is these protections went on over time through the second trial, even up to the opt-out trial. A lot more pre-canned testimony was used at trial, more videotapes, and sometimes actors reading. Actors reading is okay. I actually favor that. It seems old school, but it's actually a lot better in my view. Video testimony is the kiss of death. People do not realize how horribly tedious it is for a jury to stare at a floating disembodied head who is constantly looking to the left to see what the lawyer is trying to tell him or her, not making eye contact, generally just unbelievably bad audio, and not very good video, even though nothing is happening in the screen but taping somebody's enormous noggin. It is astonishing how awful the video. I have said this to every lawyer. No one ever listens. 5 minutes of video testimony is the equivalent of half an hour in terms of perception of an in-court exam. And the other problem with video testimony is that you cannot have that feeling we all get of having a live person and being able to judge their credibility a lot more accurately when they're on the stand and in front of you. You can see body language, you can see unconscious cues, you can see unspoken things that give you the impression that this person's telling the truth or this person seems a little shady. With video, it's very hard to do. So it was a consequence that was necessary. I get it, but that added, I think, significantly to the burden of the subsequent trials. The only advantage, I will say, of deposition testimony is when you had foreign speakers, and there were a lot of them in this case, you could dub over an English translation without having to do what you would do in court, which is a lawyer would ask a question in English, a translator would translate it into Japanese, the witness would answer in Japanese, the translator would then translate it into English, and at the first trial, at least, between the return from Japanese to English answer, the translators would often have an extended dialogue about what the witness actually just said. That is its own nightmare because it basically doubles or multiplies by 2.5 the time it takes to examine a witness when you're doing all that. So the one upside was you could kind of dub over the English-Japanese problems in a video and make it much more comprehensible. That minor upside is generally, though, outweighed by just the nightmare of having to listen to video testimony for hours, not just in this case, but in the number of other cases I've had. If I can persuade lawyers to do one thing, I know it's cheap, I know it's easy, you don't have to fiddle with subpoenas, you don't have to fight with getting witnesses, get your people to court. There is just no substitute for a live person. And if you can't do that, My personal strong view is get an actor to read it, because it is at least the jury has a three-dimensional figure they can look at while they're listening. I think it makes a world of difference in their engagement and their willingness to understand what's going on. Watch a jury. Next time you go to trial, just go to a courthouse anywhere in this great country. Watch a trial. Look at the jury while a videotape is being played. You will be astonished at how they just drop off every 10 minutes. You're going to lose a juror in the playing of that videotape, because it's just too hard to do. We're not built to do that. All right, that was my rant for the day. No more deposition. Don't play video testimony. You're all trial lawyers. Bring your people. Make them do that. I'm here to facilitate that. You need somebody, I'll reach out and bring to you. Just don't hesitate to ask. Now, it's a little hard when they live in Tokyo. I get it, but we can work things out.
It's a great point about the video depositions, because so many lawyers are, I think, trained that jurors need video. They need to see images and pictures, and it's not actually true. And not only do those videos get disjointed because they're typically cut together, right? It's not one series of testimony, but it's a lot of portions of testimony edited together, which is a strange presentation. And it's also a tremendous amount of time used, because you don't necessarily resolve what you're going to designate, counter-designate, and get objections resolved until shortly before presentation. So usually you've got an attorney and a paralegal and a tech person having to put those presentations together at the same time that you're trying to get prepared for your next couple of trial days, which if you just read it or have an actor read it, you can avoid all of that and actually have a more natural-looking presentation.
Listen, that's absolutely right. I'm just going to go on for a second. The other problem with that is dealing with objections. Okay, so when people come in with, let's say they have an hour of videotape, you all know that depositions are not at all like courtroom testimony. Lawyers feel a lot greater degree of liberty to make stupid objections and be obstructionist and act like jerks. We all know this. Okay, go read a Joe Jamail deposition transcript from the 1980s. If you have any illusions about what happens at a deposition, all right? For those of you who don't know, it's Jamail, Joe Jamail, great Texas trial lawyer, passed away some time ago. So, the problem then is someone comes in and says, Your Honor, we want to play this 45-minute deposition of a senior executive. Here is our 55-page manual of objections to all the questions, and we want you to go through this before we get into the play to the court. That's not going to happen, okay? You're going to roll the tape, and we're going to be done with it. No judge in this country has time to look at all your deposition testimony in advance and then make rulings on it. It's just not possible. So my solution to that is you work it out and you play it, and God help you if you got it wrong, because I'm not going to come in and save you. Now, with a live actor, that problem is eliminated, because if you want to make a deposition, you have your transcript. They're chained to the transcript. They're not improvising. They have to do word for word what the transcript says. But if there is an objection, I can pause and rule on it, and it works out much, much better. So I heard what Mr. Williams said about lawyers thinking people need to see screens. I think that's completely wrong. People need to see live people, but it really, I urge everyone who may be listening to this, use an actor. Don't play the deposition if you can't get the live witness. It is just a much better experience for everybody.
Picking up on Steve's point about the disjointed nature, we do a lot of mock juries before we get a trial. And one thing that I've consistently heard from mock juries is with the video clips, because it's so clear that you cut things up, they get skeptical about what they're missing. And so when you talk to the jurors after, they often will you can lose credibility with your own presentation, because they want to know, well, what did you cut out? Why am I not getting the whole thing? When they can see that they're not getting the whole thing, that starts to fixate in the mind, and then they think, are you giving me something that's incomplete and misleading? Whereas with someone reading, you don't get that disjointed nature because you can't see that there's pieces that have been cut out. And so I think that's another one of the advantages. The only downside I'll say to...
Well, I think that's absolutely right. And just also, you want to package your presentation so it's easy on the ears and the eyes. I mean, these sound like basic things, but people forget about this. So you're asking a jury to do a lot. Don't make that work harder by having a deposition transcript that cuts to, because people are speaking over each other, and the tech has no room, because all of a sudden 5 lawyers start talking at the same time, because 2 have an objection, 1 wants lunch, 3 says, can you read the question again? All this is happening, and you get this transcript that sounds like it's been run through an 8-track tape and has holes in it because there's so much popping and snapping, and that's on top of, as I mentioned earlier, the almost uniformly terrible sound quality. Many of the depositions I see indicate that the videographers are not paying as much attention to the audio quality as I think would be beneficial for lawyers who want to present this in court. So it's just, and the lawyers aren't listening. I mean, not to pat myself on the back, but every time I did a video deposition in private practice, the first thing I did was put the headset on that the videotape person was using, and I made them record a minute, and I made sure that I could hear it clearly and that my witnesses look good on camera. Okay, just do that. Just take a second, do your own sound check and quality check. It will save you so much grief by the time you want to get back to trial and play that thing. But there is just nothing worse than having not only the pure tedium of a deposition, but sonic disturbance and burden on top of that. Make it easy. Serve your audience a great product. It sounds simple, but so many people just don't do that when it comes to trial time.
Now, there were some lasting changes from the pandemic. Can you tell us a little bit more about what some of those changes have been?
From the court's perspective, we now have completely eliminated any of the pandemic practices we had in terms of masks and separating people from each other physically and so on. But the one thing that we have kept in our district, and we have found it to be actually quite beneficial, is a mandatory written questionnaire that is now used in all cases, civil and criminal, as a matter of course. We did not do that before. And what it does is now asks in advance all of the demographic basic information we used to do on the fly in court. Are you married? Where do you live? What's your education? We can ask some basic questions about the case. If it's a civil case, do you own stock in any of these companies? Do you ever work for them? We can ask expertise questions. Are you an antitrust economist? Have you ever been involved in an antitrust claim? Have you ever been a witness? We can do all of that now in these written questionnaires. People answer them truthfully. It is always deeply impressive to me how candid and honest people are with sometimes embarrassing personal details that they volunteer to make sure that they're answering the questions correctly. And then we can get these out. So what I typically do is I get these, let's say we have a jury and I'm going to seat 7 people in the civil case. I'll send out 50 questionnaires. We'll get maybe 40 back. There's always a little drop off. I can send those to the litigants, and then they can go over those. And when we have our first meeting, we have done 50 or 60% of jury selection already, because the litigants can then say, we think we have a problem with this person, here's why. We can all agree that someone who's having surgery next Tuesday shouldn't come in. It really has improved jury selection. So the one kind of unintended benefit for the court has been this really great new written jury questionnaire system that we use that I think everybody, judges and litigants, have really benefited from.
Yeah, just to echo that point, earlier this year, I was preparing for another class trial in a district that it is not standard practice to issue written jury questionnaires before voir dire. And one of the things our side decided to do was to pitch to both the other side as well as to the court the idea of using a written jury questionnaire just to do precisely the kind of pre-screening that Judge Donato just described. And, a little bit to our surprise, everyone was very receptive to it. And it really was a big time saver in terms of saving a lot of time for voir dire, in terms not just for the litigant and the court, but also for the jurors. Because if you can already disqualify someone, or someone has reason to not be selected, that really helps the potential juror as well. So I will say that, in every trial, I think this is something that at least I'm going to be pushing for before every trial, just to issue one of these written jury questionnaires just for everyone's benefit.
Well, Chris, I realize that we may have left the audience in suspense. How was this case resolved?
So ultimately, the case ultimately settled on the day that we were supposed to give closing arguments. And at least from our perspective, the plaintiff's perspective, it was a spectacular result. We settled for something roughly 140% of our single damages number, which is an extraordinary result and doesn't happen very often in civil antitrust cases. So I think it was an excellent result, at least from our perspective.
Our client Matsuo settled 3 days into the second trial in the amount of $5 million, which was an excellent settlement from our client's perspective. So we were really pleased with the result as well.
We'd like to end these episodes with key takeaways for practitioners. Chris, let's start with you.
Thanks, Anant. So I think one of my biggest takeaways from going through this trial, not once but twice, is to always be flexible and to be prepared for the unexpected. As trial lawyers, we spend a lot of time preparing these cases, but you know, it always seems like something unexpected happens. I mean, in this case, I don't think anyone expected doing a trial through a global pandemic and all the complexities that follow through from litigating through a global pandemic. But I think it was a credit to everyone, the litigants, the court, and the jurors, that we were all able to be flexible and present a pretty streamlined and effective show.
I think for me, the takeaways, to state the obvious, was to simplify, keep your presentation tight, be focused, and don't overthink at that point. You've lived with the case for years. You've prepared it for years. When you're in the courtroom with the jury, try to make it easy for them to understand what it is you're trying to tell them about the case and what they should conclude.
Yeah, I would echo that. I think even from the defense perspective, a key takeaway in any trial is always, what's the simplest, most compelling story that you're going to be able to tell the jury? I think too often on the defense side, we think our job is to poke holes in what the other side is doing, and that's certainly a key part of what we do. But at the end of the day, as the judge said, we're programmed as human beings to want a story. We want a story that we can believe and kind of sink our teeth into. And so, our job on the defense side is to present a different story that comports with the facts and the evidence that fits within the parameters of the law that hopefully the jury believes. And again, in this case for us, because of the settlements, as we talked about before, that did not have to be a story that got them to zero or even close to zero. And so that was kind of our focus in terms of the trial.
I would say the key takeaway from my perspective is just to keep the jury in mind and to focus on the themes, but also the presentation of the evidence and the witnesses that would be compelling to the jury and really retain the jury's attention through, in this case, a multi-week trial.
Here's what I think people ought to take away. Look, you've heard a lot about the challenges. Try your case. Don't be afraid. Take it to a jury. Juries are fair. They're impartial. They're dealing with a common set of evidence under a common set of legal instructions. This is what we're here to do. So have the courage of your convictions. You think you got a killer defense? Take it to the jury. You think you've got a plaintiff side case that's worth 10 times what the defendant's offering you? Take it to the jury. Don't be worried about all these details. You can work it out. Try some cases. That's what we're here for.
Well, Chris, Steve, David, Meg, Judge Donato, thank you for this excellent episode. There were so many good trial practice tips in here, and it's always great for our listeners to hear after the fact how a trial went for all the parties involved. So thank you again for your participation. To our listeners, be sure to subscribe on your podcast platform of choice, and we'll see you next time on Trust and Trade.